Encounters. My name is Robin Earnest. I'm a member of the DC Bar's Criminal Law and Individual Rights Steering Committee, and I'll be your host for today's podcast episode. Today, we're discussing and demystifying DC's Second Chance Amendment Act of 2022, which became effective on March 1st of 2025. Succinctly stated, this new law modernizes DC's outdated record sealing statute and aligns them with the broader national movement for record relief. Although the Act primarily offers a comprehensive pathway for expunging and sealing certain criminal records, it may provide a path for record relief for those pardoned as well. For eligible individuals, the Act provides an important step towards removing the lingering stigma of past convictions, establishing a favorable criminal history record, and opening doors for employment, housing, and financial opportunities, all while maintaining public safety. But as with many legal reforms, navigating who qualifies and how isn't always straightforward. That's why we're thrilled to be joined by two leading voices on this issue. Patrice Sulton, founder and executive director of DC Justice Lab, and Nye Winslow, the lab's Policy Counsel. Together, they'll help us unpack the key provisions of the Act and how it supports second chances in DC. Patrice and Nye, thank you so much for joining us today.
Thank you, Robin.
Thank you.
At first blush, the Act appears long and multifaceted, I must say. Can you briefly summarize what the Act does and why it may be important for members who practice in DC to understand its provisions to best assist their clients?
Yes. So the Second Chance Amendment Act allows many DC residents to receive record relief. There are 4 different avenues of record relief under the Act. So you have automatic expungement and automatic sealing, and then you have petition-based expungement and petition-based sealing. Now, it's important for members of the DC Bar to understand these provisions because some people may qualify for one aspect of record relief and not for others. So you want to know which aspect a person qualifies for and how to best help them receive the record relief under the Act.
Thank you. That is very helpful. Patrice, what's the background surrounding the Act? Can you tell us why it was enacted? Were there specific problems the Act was targeted to address?
Yes, for the last 20 years, DC has had one of the most restrictive and convoluted criminal record sealing schemes in the country. There were many records of non-convictions that weren't even eligible for relief. But one of the bigger problems with the law was it was so confusing and complex that a lot of people couldn't tell whether they were even eligible to go to court and ask for relief without first hiring a lawyer to walk them through the statute. So this new law really aims to not just expand eligibility, but really simplify the law so that the public has a better understanding of who's eligible and who's not eligible and which records can be sealed and expunged.
Okay, well, let's demystify that understanding for our members here. Nye, getting into the weeds now, what's the distinction the Act draws between expunged records and sealed records?
So expunged and sealed records are both hidden from public view, but the main distinction is expungement is a more comprehensive version. So if a record is sealed, that record will not show up when a person is doing things like applying for a job or applying for housing, but law enforcement will have access to that record and they'll be able to view it, use it, or do anything they want. Now, for an expunged record, the law is focused on restoring a person to the place they occupied under the eyes of the law before that arrest, charge, or conviction. So not only will it not show up in public, but law enforcement as well will not have access to an expunged record. Now, an expunged record is not physically destroyed. It's important to note that there are reasons why a person may need their record, which is why that record won't be physically destroyed. For instance, if somebody wants to bring a lawsuit against the Metropolitan Police Department or another law enforcement arm, they'll need access to their record. Also, if someone has immigration issues, they may need access to their record. So the law does not require an expunged record to be destroyed for those purposes, but it is a much more comprehensive version of hiding it from not only public view, but law enforcement as well.
Okay, that's very helpful. Assuming that not all records, however, are eligible to be sealed or expunged. So, Patrice, can you tell us about which records are eligible for either of those applications?
Yes. So, as Nye mentioned, there are really four avenues that we want attorneys to understand here. The first question when looking at a record really should be, is this even a crime anymore? If it has been decriminalized, legalized, or held to be unconstitutional by a court, this law is going to allow for the automatic expungement of that record. And courts are given a period of time between now and 2027 to get rid of those old records that have now been decriminalized. We think about things like possession of small quantities of marijuana, street vending, and those kinds of offenses. The next question is this a record of conviction or a record of a non-conviction, meaning it was an acquittal, a dismissal, or some other kind of termination of the case? And if something resulted in a non-conviction, it might be eligible to be expunged by filing a motion with the court and demonstrating that the person was actually innocent, meaning the offense did not occur or they were not the person involved. And it's sort of like a little mini trial on paper to say, look, this is not even a record that should have happened in the first place, and therefore it's eligible for that highest level of relief of expungement. If a person does not have a case to make that they're actually innocent of the offense, it may still be eligible for automatic sealing after a period of 10 years has expired. So wouldn't be expunged fully, but sealed from public view, so long as it's a non-conviction. Again, that's a dismissal, an acquittal, or anything short of finding of guilt and sentencing. And lastly, if a person's record is a conviction for a misdemeanor or a felony in the District of Columbia, they can file a motion with the court arguing that it is in the interest of justice to seal that record from public view. There are some limits on which convictions are eligible for sealing by motion. And those of you who are familiar with the DC sentencing guidelines, they're the ones that fall under master grid groups 1, 2, and 3, or the most serious violent offenses that we have on the books. But most of the felonies that were previously ineligible for any kind of record sealing relief are now eligible for the filing of a motion to ask the court to restore the person and make them whole again.
Thank you. That was very helpful in clarifying what records are eligible to be expunged. So let's say you have a client and it appears to you that they have eligible records. Nye, can you talk about what would be the process for expunging or sealing those individual records? And is it a process that has to be completed by an attorney, or can the individual do it themselves?
Yeah, so for petition-based sealing and expungement, a person can do it themselves or with an attorney. So if a person is doing that, is filing a motion with an attorney, it has to be electronically filed. And if they're doing it by themselves, then the petition needs to be filed in person or by mail. So once that motion is filed, a judge will be assigned and there will be a response requested from the prosecution. And the court has 180 days to provide a written response, a written decision for what they decide to do. So there are three different options. So let's go option one, say the motion was filed incorrectly. You'll have 30 days to amend that filing. And if it's not amended, the motion will be dismissed without prejudice. If the motion is granted, the court will send an order to MPD, the FBI, and prosecutors, and criminal records and court proceedings related to the citations, arrest charges, or convictions will be sealed or expunged within 90 days. Now, if the motion is denied, you can file a second motion after 1 year, but motions to seal a different record can be filed at any time. If that second motion is denied, you can file a third and final motion, and that can be filed after another year has passed.
And Nye, are there time limitations for the records? For example, does the record have to be expunged? Does it have to be 5 years old, or other qualifiers before the process begins?
So there are three different time periods that we should focus on. For petition-based sealing of misdemeanor convictions, there must be a 5-year waiting period after the completion of the sentence. For petition-based sealing of felony convictions, there needs to be an 8-year waiting period after completion of the sentence. And it's important to note that not all felony convictions are eligible. Those under master grids 1 through 3 are ineligible for record relief. And then for automatic sealing of misdemeanor convictions, there needs to be a 10-year waiting period after a completion of a sentence for someone to be eligible for that.
Thank you. So, in reading the act, I was struck by the fact that it expressly appears to only address expungement and sealing of records. However, recently there's been a lot of talk surrounding pardons. How do they differ from expungements and sealing of records, and what impact, if any, might the act have on pardons?
Thanks for that question, Robin. We've heard a lot more about pardons in 2025 than we're typically used to hearing about in DC. And it's important to understand that a person being pardoned no longer has the weight of a conviction on their record and is no longer under sentence, but it doesn't automatically have the same effect as expunging that record. For example, under the federal sentencing guidelines, a pardon is still going to count toward the person's criminal history score, but if the person then seeks record sealing relief in the form of an expungement, it would no longer be part of that calculation. Under the DC sentencing guidelines, that isn't the case. It still counts either way, even when it's expunged. So it's important to be mindful of which jurisdiction you're in. And of course, we always advise that people reach out to the U.S. Sentencing Guidelines helpline if you have questions about an individual case to make sure that you have those calculations right.
Thank you for that clarification, because there has been a lot of confusion. I did speak to one attorney who wondered whether or not a person who had received a pardon would that qualify for getting that conviction expunged under DC's Second Chance Act. Do you have thoughts about that?
So expungement is available for non-convictions if you can demonstrate actual innocence. If there is a finding of guilt or an admission of guilt, say a deferred sentencing agreement where the person pled and withdrew that plea, it does make it more difficult to persuade the court that the person was not involved or that the offense didn't occur. So legally, there's no real bar there, but it is certainly a pretty tall hill to climb to demonstrate actual innocence after a finding like that.
Thank you. What is the difference between automatic and petitioned record relief, and is there a benefit?
Sure. So the main difference between automatic and petition-based record relief is that for automatic record relief, the person with the record and their attorney, you don't have to do anything. Once that person falls under a certain criteria or meets certain requirements, the court will automatically seal or expunge that record. And so that portion of the law goes into effect next year. And courts have until October of 2027 to retroactively automatically seal and expunge old records. For petition-based sealing and expungement, that requires a person or their attorney to file a petition with the court to petition the court to have that record sealed or expunged. So there's a different set of qualifications that a person needs to meet in order to be able to petition the court for record relief. And if there are benefits to both, the easiest form for people is to have that automatic record relief, right? So if you don't have to do anything, you meet certain requirements, and the court will automatically expunge or seal that record, that's great. I think the great thing is we can see in the law and in similar laws across the states, it's a very high bar to qualify for automatic record relief. So allowing people to petition to have their record sealed or expunged really opens up the record relief law to more people. And I think it's a necessary addition that more people can file for record relief and get access to these things like housing, employment, education, and these other resources and move forward with their lives.
And we certainly hope that they do so. Interestingly, Nye, you mentioned that the record relief doesn't go into effect until next year. Are there other provisions of the Act that have a delayed enactment similarly?
I believe the only delayed portion of the law right now is the automatic record relief that's going into effect in the beginning of next year. The petition-based record relief portion of the law went into effect in March. So as of now, as of today, people can petition the court to receive record relief for their criminal records. But for the automatic portion of the law, you have to wait until January 2026 for the court to start automatically sealing and expunging records.
And I know it's early days because it just went into effect in March of this year, but what benefits have you seen from implementation of the act, or what benefits are you expecting to receive from its implementation?
Well, I was excited to learn that some of the legal services providers have already had records sealed and expunged under the new law. The biggest impact, I think, is eligibility for certain felonies. As you know, we have a really outdated criminal code that has yet to be modernized, and we have a lot of conduct that's characterized as felonies that shouldn't even be a felony. And so to have people locked out of relief for so long was really a disservice to people who had records in DC. So opening it up to felonies is a big impact. And then just simplifying the law dramatically makes a big difference, that people don't have to necessarily hire a lawyer to know what's going to happen to a record if it's eligible for automatic sealing or expungement. Also, enjoyed conversations with colleagues over the last several weeks who reminded me of other things about the law change that got me excited. There are a lot of drug-related offenses that people have on their records for things that, today would not be considered a basis for enforcement or arrest. And there are some misdemeanor offenses that were long ineligible for any kind of relief that are carved out as exceptions to automatic sealing, but people can finally file motions related to things like DUIs, intrafamily offenses, and a whole host of things that previously were ineligible for relief. So excited that it's going to open up these opportunities for all of these records to incentivize people to be able to make that case that they are really deserving of a second chance.
Terrific. And, we've spoken a lot about procedurally, how do you access the provisions of the act? How do you become eligible? The time constraints. But can you talk a little bit about the more compassionate benefits that you expect, that we all expect to receive from implementation of the act, from providing the record relief that was the impetus for the amendment? And again, realizing it's been early days for this act, but maybe the benefits that have been seen in other states that had a similar act in place for a longer period of time. What can we expect to get excited about?
Yeah, so we know at least 12 other states have passed similar record sealing laws throughout the country. And what we've seen in these states is that, and especially and particularly in Michigan, Utah, and Pennsylvania, there's been polling about how people have received record relief and some of the impacts that it's had on their lives. And over 20% of people have said they've seen an improvement in housing and in education. And over 40% of people said they've seen an improvement in their employment and personal finances. So we're already seeing in states throughout the country huge benefits to and tangible benefits to people's lives. And I think we can really expect that to happen here in DC, and that people will be able to get better access to all of these resources that will help them and their families move forward and decrease the chances of recidivism amongst these people.
Thank you, Nye. That's all terrific. I'm really excited. How can our members find out more about getting training and help for their clients to navigate the complexities of the acts to start seeing some of these benefits in the DC area?
Please stay in touch with DC Justice Lab. We have a website called dcexpungement.com that is an easy reference for anyone who wants just a snapshot of how this new law works. But we are available to DC bar members who are interested in learning how to take on these cases themselves. It's a great opportunity for pro bono work for people who are not necessarily steeped in criminal law and procedure. It's easy to learn and really rewarding cases to handle. You get to connect with clients and sharpen those client counseling skills, and really make a big difference with a lower lift than some other kinds of criminal law pro bono opportunities. So really hoping that we can be helpful to anyone who wants to learn more, and available to put on CLE trainings for you or your firm.
Thank you. I will be taking you up on that offer without a doubt. So before we go, and time has just flown by, I want to throw the question out to the both of you. Is there anything that I failed to ask that you think it's important for our audience members to know about the Act or DC Justice Lab's involvement in it? What would you like to say?
Well, I'd love to share that I got involved in policy work while I was a practicing attorney, and I was surprised to see how few people who work on lawmaking full time really understood how the words on the page play out in the courtroom. So I just would love to encourage practitioners and DC bar members who might not do policy work full time to share their voices with lawmakers and decision makers in the district so that they can really understand how legislation works in practice.
Yes, there's a reason why we call it a practice. It is an ongoing learning opportunity, and we so appreciate your part in that for us. And we thank you both for your discussion here today. Unfortunately, it's all the time we have for now, and yet it seems like we've barely scratched the surface of this very interesting act. Listeners, if you're interested in learning more about the Act, you can download it from the DC Council's website, or you can read about it at dcjusticelab.org. You can also learn more about our speakers from the show notes. For now, I'd like to thank our esteemed speakers for sharing their expertise, the bar staff for their tireless assistance, and you, our listeners, for your time. Thank you.